All right, I see we are live. Good morning, everyone, and welcome to session 3 of our From Bids to Bricks series. On behalf of myself, Jessica Foster from Gowling WLG, and of course my co-chair Kyle David from Aon, we'd like to extend a warm welcome to all of you online joining us this morning. Again, thank you so much for making time in your busy schedules to be here. Your support and engagement are truly what make this series possible. Okay, just a few quick housekeeping items. Of course, everyone's microphones are muted and cameras will be off. A quick reminder, this session, like the others we've done thus far, is being recorded and we will be sharing that after the webinar. You are able to ask questions anytime by clicking the Q&A icon at the bottom of your window. We will be monitoring that chat and we'll pose these to presenters at the appropriate intervals. Next slide, Erica. And of course, just a quick legal disclaimer. The presentation for information purposes only. It is not legal advice. And of course, Gowling WLG professionals would be pleased to discuss any specific legal concerns you may have. So never hesitate to reach out should you need assistance on any of the topics covered here in this webinar. Kyle, over to you.
Thanks, Jessica. Hello, and thank you again for joining this morning. Today's session is called Cover Your Assets, Professional Liability and Construction Acts Lien. Cheeky title that's fairly self-explanatory. And Jess, I'll pass it back to you.
Great, thanks, Kyle. One more quick housekeeping note for the lawyers in the room. A reminder, this program is accredited and will count for up to 1.25 substantive CPD CLE hours. As we have done for the past 2 sessions, you will be receiving a feedback survey after the program today. As always, I encourage all of you to please take a quick moment to fill it out so we can ensure on a go-forward basis the content that we are providing is as relevant to you as possible. So with that, we will be kicking off today's presentation with liens, broadly speaking. So I would love to introduce my colleague, Ted Betts. We are very grateful to have Ted here presenting today. Ted is not only the head of Gowling's infrastructure and construction sector group, but also one of Canada's foremost project authorities with over 25 years of experience in the construction and infrastructure sector. Ted's practice focuses on large-scale construction, infrastructure, and development projects, particularly power generation, transportation, urban development, city planning projects, and P3s. Kyle, over to you.
To introduce my colleague, Jelena Stojanovic, who will be following Gowling's lien content. Jelena is a technical leader from our professional services group and carries a depth of knowledge in delivering professional risk solutions for projects across the country. And with that, over to you, Ted.
Well, welcome, everybody. We're going to do a rapid fire speed dating version of the Construction Act. Underneath all of the things that we've been talking about in this great program on bids to bricks is an actual statute, the Construction Act, that sets out a number of fundamental rights that are different than other commercial arrangements and other commercial agreements. We're so used to the concepts that we often ignore them when we get to the contracts, but underlying them and understanding these basic concepts is critical to understanding how they need to be drafted, understanding how when disputes arise, how they need to be addressed, and as we'll learn next month, understanding how the amendments impact the cash flows on a project, because amendments are coming, and starting with a base understanding of lien rights and holdbacks and construction trusts is critical to understanding how they get changed and how they apply to the cash flows on a project. So we will have some slides going forward. If we could move forward, we're going to talk first, just setting the table with some basic key definitions, and then get into lien rights, holdbacks, a brief touch point on construction trust, and then we won't talk about the key forms, but that's there for when you get the copy of the slides. that you can see, have an easy list of all the key forms that are prescribed in. Move to the next slide. So the Act starts with the concept of an improvement. That's the language we use to define a construction project. It's very broad. And if we can move to the next slide, we'll come back to the concept of improvement because it anchors everything that we look at to define whether you have lien rights, whether holdback applies, and whether these definitions even apply to the drafting or the project that you're working on. Other key definitions include owner, contractor, and subcontractor. I put that up there. That seems obvious, but on the one hand, it's important to understand that these are specific roles and relationships. The owner is the person who has an interest in the land. So presumably that's obvious. There's somebody who owns land, wants to build something on it. But it's broader than that. Anybody who provides credit but takes an interest in the land, so that would be a lender. If they take an interest, a mortgage in the land, then they are considered an owner. You could have multiple owners. You could have a landlord. You could have a leasehold tenant. Anybody on whose behalf who's paying for the improvement is going to be considered an owner, and that will matter. There's one key exception that many people on this call will face, and that's in P3 projects, where there's an exception where you've got the government authority, say it's a hospital. They're clearly the owner because they own the land. But the way the P3 projects work, all of the work and risks of the project itself, including payment, are dropped down to a project company. So in that case, the project company, for the purposes of the Act, is treated as the owner as well, even though they're technically a contractor. So that's one important exception. The contractor, other than that, the contractor is always the party who has a contract with an owner. So anybody who does not have a direct contract with a party who is an owner is going to be a subcontractor. So we could move to the next slide, just graphically showing what that looks like. You've got the owner at the top, contractor, and subcontractor. So important to note, the consultants, architect, engineer, if they've got a direct contract with the owner, they are also a contractor, and the subconsultants that they hire are subcontractors under the Act. Could move on to the next slide. Two other very key definitions, and we will come back to this. These get used a lot to anchor certain timelines and rights that expire on liens and holdbacks. Substantial performance. This is defined in the statute in section 2.2, subsection 1. It has two parts to it. The first is a functionality test. Is it ready for its intended purposes? Or is it being already used for its intended purposes? The second is a financial test. So if you look at the contract, and this is a place where it matters to understand who's the owner and who's the contractor, because a contract is the contract between the owner and the contractor. So the price that's in there will be a certain amount. This financial test is looking at how much of the work has been performed as against that contract price. So it's a financial test based on the amount of work that's been performed to the point. And roughly speaking, rule of thumb is about 97% of the work done gets you to substantial performance, as long as it's ready for its use or is being used for its intended purposes. So what's left? The left between substantial performance and completion is fixing all the deficiencies, doing the final cleanup, demobilization, that sort of thing. So if all of that leftover work does not drop you below that financial threshold test, then that's what's left for completion. And completion, even with completion, we have a little bit of a buffer of the 1% or 5,000, and that is meant to recognize the reality that, you know, it's rare that a project could be said to be 100% completely done. So they give a little buffer, but basically completion means it is all done, and those are two key definitions. If you're used to other provinces, these are the definitions in Ontario. There are slight variations across the country on these, so it's important to look at the definitions in each province. Next slide, please. All right, now let's get to the lien rights. So we mentioned improvement is the anchor to understanding if you have lien rights. The Act in Section 14.1 says that anyone who supplies services to an improvement or materials to an improvement for an owner, contractor, or subcontractor, has a lien automatically the moment you start performing any work. So as long as you are meeting the definition of an improvement, that's very broadly defined, or you are providing an essential service for an improvement, meaning you are, think of your security fences around a construction site. That's not actually an improvement to the property, but it's essential for the safe performance of the work on a property. And so as long as you are performing that work for an improvement or an essential portion that allows the performance of the work for an improvement, you have lien rights. There's an express term that this applies to architects and engineers. And the way to think of a lien, we talk about lien claims all the time, but the lien is actually more like security. It doesn't change. Having a lien right does not give them any more right to more money or more rights than they are allowed under their contract, but it is security. And ultimately, if they are not paid, they can bring a lien claim, which can go to court. And if they win in court and they still don't get paid and they go through all the appeal processes, at the end of the day, the power of the lien is that they can actually force the sale of the land with the building on it and recoup their unpaid portion of their fees through the sale of that land. That's the power of the lien. Now, that does not happen very often. It happens sometimes, rarely, usually always because of an insolvency. But that's the power of the lien, and it drives people to get to the table to talk about the dispute for the non-payment or whatever it is that's there. As I said, it arises the moment any work is done at all, whether the payment is owing, or maybe you've got milestone payments or completion payments at the end. The lien right starts the moment the work is done. And these are rights that cannot be waived. We move to the next slide. So, and it applies to anybody who is supplying services or materials. Now, we won't get into the detail discussion here about where's that line, because it is a whole session on the gray area between somebody who's clearly doing construction work on site to somebody who's supplying goods and materials. There is a nexus of the project. If you are providing supplies and materials that are specialized, special ordered, if there's knowledge that these are being used and manufactured in bulk for a construction project, then it's probably got lien rights. But there is a lot of gray area there, so that we're not going to get into. But just bear in mind that if you're simply providing nails from Home Depot, that's not going to be, you're not going to have lien rights. But if you're providing specialized screws that are needed for a special type of equipment that are being installed on that particular site, then you probably do have lien rights. As I said, the power of the lien is that you could ultimately force the sale. Now, that there's an exception for the Crown, municipalities, and broader public sector organizations, because these are public goods, and obviously we don't want that to happen. We can't allow that to an unpaid lien to result in the sale of a road or a school. So we say that does not attach and couldn't force the sale of lands. The lien right still exists. It's there as a claim, but it doesn't allow them to force the sale of land. And then there's certain key exceptions for public-private partnerships when it comes to the structure of the lien right. Can we move on to the next? Just given our time, we're not going to get into the details there because we do have to get into more on the lien rights and holdbacks. So what is a lien right? The lien right is this power to get paid, basically, when you haven't been paid. But the lien right, because it's a creature of statute, it exists only because of the statute and by the rules of the statute. There is a lien period at the end of the project, after which your lien rights will expire. And once they expire, there's no reviving them. There's no, oh, oops, we missed a deadline because we calculated it wrong. We didn't think we had lien rights. We didn't know the project was winding up. So it's really important to understand these next two slides in terms of your lien rights. There's a two-step process to preserve and perfect your lien rights. The first is, we call it the preservation of your lien rights. So for a contractor, at the end of the project, so this is the party who has the direct contract with the owner, when you hit substantial performance, there's a certificate that's issued to declare, or a declaration of substantial performance. This needs to be published, and the clock, a 60-day clock, starts ticking. That's your lien period from the moment of publication. It could also start if there's no certificate or declaration. It can start from the day the contract is completed, abandoned, or terminated. But it's a 60-day window. At the end of that 60 days, if there is no liens preserved, then you lose your lien rights. And you preserve it by a written notice of lien or registering a lien on title. You can go to the next slide. There's a similar but slightly different obligation to preserve your lien rights for a subcontractor. Your performance of the of work under your subcontract will dictate your scope. When your scope is done, you will have the 60-day start automatically from the last day of supply of services. So think of the subcontractors who are performing early in the project before substantial performance. Their lien rights expire much earlier than the contractors. So they will finish their work, hit completion, and then 60 days from there will be the end of their lien period. If they're working right through to the end of the project, then they have the same rules as the contractor. So when the 60 days from the certificate of substantial performance being published, or the date the subcontract is completed, abandoned, or terminated. And it's preserved, the subcontractor's lien rights are preserved in the same way. Written notice of lien or registering a lien on title. Next slide, please. So once it's preserved, if you have preserved, and only if you have preserved, you then have 90 days to perfect your lien rights. And you perfect it by really coming to the table with an actual claim. So the idea here is this 150-day period. You preserve your lien rights within the first 60 days, and then you have 90 days extra to decide and try to work out this dispute. And failing that dispute, you have a right to perfect your lien claim by commencing an actual proceeding. If you don't, you lose your lien rights. Next slide, please. So just to graphically show that, this will be in the slides. You've got a 60-day lien period followed by a 90-day lien perfection period. And that's the same for both contractor and subcontractor. Next slide, please. So we're all familiar with the concept of holdback. So just to get into the specifics of what it is and how it gets released. In the Construction Act, there is a statutory obligation to withhold 10% of every payment. This is the statutory holdback, and that is paid after the work is done. There's three types of holdbacks. The basic holdback, which is what we're going to focus on because that's the bulk of the holdback. There is a finishing holdback, and that's covering the period from substantial performance to completion, that bundle of work that we talked about, demobilization, cleanup, deficiencies. There might be still some finishing work to do. That work has its own holdback and a separate holdback period. And then anytime there is a written notice of lien, there's a requirement to hold back. So we're not going to get into that. That's just a function of the dispute process for lien claims. But the basic holdback, if we could skip to the next page, is held back through the whole project. We'll talk about some ways that can be released early, but the basic principle and rule is that the holdback is held by the owner until the end of the lien period. That's that 60-day window after substantial performance. And on the 61st day, the owner is required to pay that unless they've filed or issued a notice of non-payment of holdback. That's a statutory form. But the holdback doesn't get released till the very end of the project. For the act does allow certain early releases, so we might see language in a contract that talks about early release or progressive release of holdback. What that typically means is for a subcontract, there is a provision in the act that says if the subcontract is fully completed, then you can release holdback to that owed to that subcontractor, but it must be fully completed. So you're think about the formwork or the concrete pouring or the demolition at the beginning of the project. If that is under the same contract that the contractor has with the owner, then they are not entitled to their holdback until 60 days after substantial performance, a publication of the certificate of substantial performance. That could be years on a big project. And so they have a provision that allows for the early release of that holdback if that subcontractor has no other work on the project and is completely done with their subcontract. In 2018, we introduced three other ways that holdback can be released. One is on an annual basis, and the other is on a phase basis. If it's a project that's over $10 million, and in the one case, longer than 1 year, and in the other case, if you've defined phases in your contract. And then the other way is really kind of an exception that gets used only in unique circumstances. But that is if you've got multiple projects on separate parcels of land, there's a provision in the act that says you can treat those as though they are separate contracts altogether for the purposes of substantial performance and releasing holdback. The holdback is a big cash flow issue for many contractors and subcontractors. And so the amendments in 2018 also brought in the concept of allowing a holdback bond or a letter of credit. So some alternative instrument that stands in place of the actual cash holdback. And so if you get a bond or a letter of credit and you've agreed how that's going to be paid, then the owner is allowed to release the holdback to the contractor is allowed to release the holdback to the subcontractors. And so that smooths cash flow on the project. As we will talk about next month, the act is being amended. One of the key amendments is that following these amendments, holdback will be mandatory to be released on an annual basis. And so all of this holdback release rules will be more or less shunted aside. There will be some provisions dealing with the surrounding periods of time when the completion doesn't land right on an annual date. But the important thing to recognize is that we are in the process of amending. We are expecting the amendments they have been passed, so they are almost law, but they are not effective yet. And we're expecting them to be made effective in January, maybe February, once they finalize the regulations that go with the amendments. So going forward, every project will be required to retain holdback in the normal course on every payment, but release them annually. And there will be a process. There'll be a publication requirement, just like at the end of the project, and then a 60-day lien period, just like at the end of the project, and then the release of the holdback. We could move to the next slide. So I just want to touch on another really critical piece that's in the Construction Act that sometimes gets ignored until there's a dispute. It's probably one of the most powerful tools a subcontractor or contractor has when there's a dispute. And that's a construction trust that gets created by the Construction Act. In short, any money that any party on the project receives that they owe to somebody else on the project, there is a construction trust over those funds. What that means in law is that there's special duties, special fiduciary obligations in how you handle that money. And if you mishandle it, then there are special penalties, not just for the company, but for the individuals who mishandled those funds. So you can see right away how powerful that is, because if you think you've got a shell company and you can do whatever you want, take this money from this project and start paying off overdue accounts on another project, or pay your shareholders with the money that you just received from an owner, you are breaching the trust, and you as a director, as an officer, as a project manager who authorized that or allowed that to happen, you can be personally liable. So it's a really powerful and important thing to be aware of. It's so normal course because it's so important to get right that most people don't think about it, but I thought it would be important to flag. And there are important rules in the Act about how you treat the funds. They're trust funds. They should be in a trust account. They do not need to be in a separate, segregated trust account for each project. I think on big projects, it's pretty much standard practice and best industry practice to create a separate bank account for that project. That's not strictly speaking necessary, but there are accounting rules. You do have to track all the money going in and all the money going out in accordance with the Act and the accounting rules and basic accounting rules so that it's traceable. And that's all in the Act in sections 7 to 13. And that flows down all the way through to anybody on the project, whoever receives money that they owe downstream. And that includes when an owner receives borrowed money from a bank or puts money aside in a reserve account for a project. So that covers construction trust. In fact, that's your speed dating 101 on the Construction Act, liens, pullback, and trust. The last slide I've thrown in there, which you'll see when you get your copy of the slides, is just a list of some of the key forms that you should be aware of and where to find them and what number they are. So with that, I'm happy to take any questions. Obviously, a lot of that is very quick highlights of some of the key concepts. There's a lot of if it was as simple as that, there wouldn't be any disputes, and my litigation partners would be quite bored. And I can tell you they are not, especially these days. They're very busy. The Construction Act is a complicated act and gets increasingly formalized with procedures and rules, and it's important to keep that up, which is why we separated out this basics with the amendments that are coming next month. Are there any questions being sent in through the Q&A? I see some. Would you explain how a construction manager under a CCDC 5A is or is not a contractor? They have a contract with the owner. They are a contractor under the Act. So a 5A just for people who aren't aware, 5A is a particular form of construction management contract where the construction manager contracts with the owner to provide construction management services only. All of the actual construction work that's going to be performed by trade contractors is in a separate contract directly with the owner. So you think of your mechanical or your carpenter, your drywaller, your however you've structured your project, all those individual trades might have individual contracts with the owner. So they are all contractors. They all have a substantial performance date that might be different one from the next. And the construction manager is a contractor with a direct contract with the owner for the provision of services in relation to an improvement. For architects, does it apply to design or just when improvement commences? So this is, and we'll just touch on this because it's actually fairly complicated, and it will be based on the real facts. But basically, the concept is when a designer is just doing some paperwork, have they actually, just coming up with concepts? We'll build a building. It'll have 37 stories, or it'll have this purpose. Here's all the technical needs that we probably need to put into there. Mapping out a plan for getting this done. That's just on paper and it's on a desk. Has it improved the value of the property? At that point, it has not. At a certain point, those designs get more formalized and they get more detailed, and they start to crystallize into something that does create a lien right. And so if you, for example, have issued for construction drawings or the design that you go to get a building permit, that's absolutely attracting a lien right, sorry. And so you've got a transition from one phase to the next where you have to look at it closely, what's being provided. I would also say, though, think of a design build. If you've got a design build and the design is inside that design build contract, there's still one contract. And so all of the work under that contract is creating the work for that improvement. And so, from the perspective of the owner and the contractor, the design builder in that case, there's only one scope. And so holdback lien rights apply to the whole thing. So there are kind of exceptions to that. But it is a tricky one, and it's important to understand the different phases. How will Bill 60 changes regarding the Construction Act affect holdback changes? So I think we touched on that, and I think we're getting into a little bit more on the amendments next month. Sorry, we covered that. Just cognizant of time and looking at the few questions that we have left. For the trust funds, if a subcontractor misses deadline to preserve perfect, do they have a right to the trust funds? So the trust funds, that go back to what I said about what is the lien. It's a security for payment, but the payment is only what's under the contract. So it doesn't create a new right to get more money. So if you had a contractual obligation to pay somebody and you've received money from somebody else, that's when the trust gets created. That's a separate thing from whether you owe the money or not to your subcontractor. So if you've missed the deadline to preserve or perfect your claim, you still are owed the money. You just don't have a lien claim. So if I receive money and I don't pay you, and you never preserved or perfected your lien claim, you don't have a lien claim. You don't have a lien rights any longer, but you still have a contractual right to get paid what you're owed. You just don't have that super powerful tool of a lien claim. So that's how those work together. And especially if that owner or that contractor who's received the money has taken that money to pay somebody else, especially if it's not on the project, then you absolutely still have that trust claim. So a last question, and just quickly, because I've kind of partially answered this already, is that the basic rule is if you have a lien right, then holdback applies, period. So once you trigger lien rights, if you have lien rights under the Act, then all of the other provisions of the Act will apply. It's the same test. If you are providing materials or supplies to an improvement, then you have lien rights, holdback applies, prompt payment applies, adjudication applies, trust claims apply, and all of that flows from that one concept if you have lien rights. And so there may be practices, and it's quite common for architects and engineers and certain supply only contracts to say, hey, look, holdback doesn't apply, or we're not pricing in holdback, so you have to pay us. And there's tools to protect people from the consequences of that. You have to really look at the risk, but strictly speaking, that would be non-compliant with the Act. And so you bear the risk of that. Now, when you don't hold back, I maybe didn't mention the consequence of not holding back under the Act is that the person who did not hold back, let's say an owner, chooses to pay the architect, and the architect goes bankrupt. So you've paid the holdback to the architect, and the architect goes bankrupt and never paid the holdback to their subconsultants. The subconsultants can come back to the owner, or the subcontractor can come back to the owner and say, you owe me the holdback, and it's no excuse that you already paid it to the contractor or the architect. If you paid it when you were not supposed to pay it or allowed to pay it under the Act, the owner may have to pay that twice if the subcontractor never got their holdback. That's the important thing to understand about following the holdback rules. So I hope that covers all the questions. It seems like we've got all questions answered. And so with that, thank you, everybody. And of course, if you have any further questions, my contact information is on the screen right now. Feel free to follow up with us.
So construction professional liability is a group of insurance policies created to protect design and construction professionals such as contractors, design builders, engineers, architects, or those who hire them, i.e. owners. Coverage under the policy is for negligent acts, errors, omissions of insured professionals. Some policies can provide broader coverage. However, this is the basis for all policies. Professional liability policies cover legal fees, settlements, and judgments up to policy limits. So before we get into a discussion about the specific policies, I wanted to make sure that everyone has a good understanding of what these policies are intended to cover. It is really important to also be clear about limitations of these policies in order to also understand the risks which are assumed under contracts and uninsured exposures. So policies do cover professionals for claims against claims of negligence in professional services they provide. So we will get into all of these concepts separately. Okay, so who is a professional? It's a person that has mastered a complex body of knowledge and skills through prolonged education and/or extensive training. What is important to keep in mind is that every insurance policy has their own definition of what they consider a professional. So it is really important to read that definition, and if it doesn't jive with your company's employees' experience, then the definition should be modified. All right, sorry about that. Okay. So back to who's a professional and various insurers' interpretations. So some insurers require professionals to be licensed, and others require a specific number of experience. So for example, not less than 5 years of experience in the field. Again, you have to read the definition and make sure that it actually corresponds to the level of experience of your employees. Next, we'll talk about the standard of care that the professional is held to. So the standard of care represents a standard of performance that others have a right to expect from a professional. The common law standard of care for performance is generally seen as the ordinary and reasonable care, usually exercised by somebody in that profession on the same type of project, at the same time, same place, under similar circumstances and conditions. So nobody is going to expect perfect performance. So what does a breach of the standard of care look like? Let's say if an engineer is responsible for designing structural foundations of a building. So instead of following applicable codes, conducting proper soil analysis, they use outdated load calculations, ignore geotechnical recommendations, and as a result, the foundation can't support the intended load, cracks appear in the structure, and that leads to costly repairs. That is something that would be coverable under the professional liability policy, as it would be negligence on the part of the engineer. Oops. So professional services, this is another extremely important definition in the policies, and it does have to correspond to the professionals that are being covered under the policy. So this definition is from an architects and engineers policy issued by CV Star. So services the insured is qualified to perform for others in their capacity as architect, engineer, landscape architect, land surveyor, agency, CM, interior designer, graphic designer, scientist, technical consultant. If you're insuring contractors under the policy with the designers, you would want the contractor's professional services to also be reflected in this definition. Also keep in mind when we're talking about project-specific policies, consultants could be added during the policy term, so it's important to make sure that this definition is reviewed once the consultants are added, and also the scopes of work may change, so this clause should be revisited for adequacy. Now, contractors, some contractors, not all, they do say that, hey, we have general liability policy, we don't really need professional liability. But when you read the general liability policy, it does exclude professional services. So you can look at the exclusion specifically for professional liability, as well as a definition of professional services under the general liability policy. And what you'll see that is typically excluded are supervisory inspection, engineering, architectural services, preparing, approving, failing to prepare or approve maps, drawings, opinions, reports, surveys, or specifications, or providing or failing to provide instructions, directions, or warnings. So these are all services that are coverable under the professional liability policy. And also keep in mind the general liability policy covers bodily injury and property damage only as triggers. It doesn't cover the financial loss trigger. A lot of the professional liability policies, policy claims are covering financial losses rather than BIPD. So as a claims example, and this is one of our clients, they were redirecting traffic during highway construction, and they were placing cones and signage on the roads to narrow the lane. There was a traffic accident which resulted in bodily injury. The claim was reported to the GL carrier, who then said, you know what, the signage and placement of cones basically are a professional service. We're denying this under the GL policy due to professional liability exclusion. And the claim was submitted under the professional liability policy instead. So for those who are not yet convinced of contractors needing professional liability coverage, the contractors with contractual liability for design, such as design build or EPC contractors, would definitely need professional liability. But there are other services that are undertaken by contractors, such as constructability reviews, value engineering, design assist, delegated design, construction management. All of those are professional services which are covered by the contractor's E&O policy. So for example, of a value engineering claim, the contractor designed a roof system for a manufacturing facility, and they subcontracted the construction to a specialty roofing contractor. And after the facility was completed, there were some major issues with the roofing system. The manufacturer declined the warranty because the roof was installed without a vapor barrier. So after some digging, it was discovered that the contractor's in-house designer changed the roof system to one without the vapor barrier due to budget issues. So the designer didn't conduct any due diligence that would have shown the new system wasn't appropriate for the facility, and the contractor had to replace the new the roofing system with a new one for a cost of $750,000. So this brings us to our next topic, which is how to cover professional liability risks. So professional services, they can be covered under annual policies, as we all know. But I mean, for the purposes of this presentation, we will focus on the various single project policy options. And now that we understand what the professional liability policy covers, we can move on to the specific policies. Just keep in mind, every insurer pretty much has their own version of the policy, which is slightly different from another insurer's. And they also title these policies and the coverages differently, but in general terms, they, cover the same things. So why should we get a project-specific policy? I mean, it's becoming increasingly important for large and complex projects because consultants typically carry 2 to 5 million per claimant in the aggregate annually. Contractors maybe slightly more, around 5 million, but as we just discussed, some contractors are not purchasing annual professional liability coverage for themselves. So, and these annual policies, the limits are shared amongst all the work that the professionals do. So any historical project where the claim could come in, the policy from that year is going to respond. We'll talk about claims made and reported policies in a second. And these policy limits are typically inclusive of defense costs, and defense costs and expert fees can significantly reduce what is left as available to pay for actual claims or rectification, damages, etc. Also, professionals do often negotiate low levels of, they limit their liability to low levels, sometimes even just to fees, and the fees could be minimal. They could be in the hundreds of thousands, which really does not reflect the risk exposure from professional liability claim. So architects and engineers, other consultants, they just might not want to expose their full limits to one contract, which is why they will look to limit their fees to a low amount or to low limits of insurance. In terms of when we arrange project-specific policies and what types of projects, I mean, typically for projects over $50 to $75 million, projects smaller than that are deemed to be adequately insured under annual policies. So what is a project-specific professional liability policy, and what does it cover? It's a policy that would be purchased for a very specific project. It's either due to a contractual requirement or a risk management practice. We do have clients who, particularly for design build projects, every design build project over a certain value, they purchase single project policy for. The limits are per claimant in the aggregate and inclusive of defense costs. And the coverage is only for the insureds that are declared to the insurance company. So typically we obtain a list of professionals with associated fees, and those are the insureds under the policy. It is best practice to have an organization chart to provide to the broker to ensure that all the appropriate organizations are listed on the policy. And again, during the term of the project, if there are any changes, you do need to notify the insurer of those changes. The policies are written for the construction term plus an extended reporting period. So this extended reporting period is typically 36 months. It can range, but typically it's 36 months. And this is a period of time after the policy expires, which is typically a substantial completion, and it allows the insured to report claims under the policy. It's a claims-made policy, so it means that claims have to be reported during the policy period or the extended reporting period. The reporting obligations, they apply by policy section, and we will go into these policy sections, but it is important to keep this in mind because each of the sections has potentially very different reporting requirements, and if you miss them, the claim could be denied for late reporting. The retroactive date should be the date of first professional services rendered, and sometimes we have clients who are concerned that well, why is my policy getting incepted at the start of construction rather than at the start of design? At the start of design, there's very little exposure to a loss. So typically we incept at the start of construction and retroactively provide coverage to the date of first professional services rendered. Total market capacity does vary depending on the project type, size, and duration, as well as market experience with project participants. Unfortunately, large civil projects have had quite a lot of issues. Some projects have had, well, hundreds of millions of dollars in demand amounts being filed against the policies. So needless to say, some insurers are a little bit shy when it comes to providing capacity on design build projects or on mega projects. And we will also go through different types of these policies, but insurers don't typically deploy capacity on more than one policy type. So if we have architects and engineers policy and a contractor's policy, one insurer will pick one of the two policy types. They won't provide limits on both. Policy exclusions are also a very important part to understand. The first exclusion I'm going to speak about, and this is what the policy does not cover. So contractual liability, including warranties, guarantees, liquidated damages, is excluded unless liability would apply in the absence of a contract or agreement. So the policy is meant to cover what the professional would be liable for at law. And that's the standard of care we spoke about before. There are words in the contract that can alter the standard of care on a project. So, and therefore the assumed liability, these are promises to perform according to the highest standards in the profession or best professional standards. Other clauses in the contract could require services to be performed to the client's satisfaction or be free of defects. If you, as a professional, obligate yourself to a higher standard of care via this type of language, this increases your exposure to uninsured claims because of the contractual liability exclusion. So another item that we often see in indemnity sections is the obligation to defend your client regardless of negligence. So without the prior finding of negligence, there's no legal obligation for the professional to pay defense costs to their client. And as such, the policy might not reimburse these costs at all. So as an example of a standard of care being modified by contract, engineers that designed the tunnel agreed in their proposal to the client to provide their services in accordance with leading international standards. Some material subsequently corroded and failed, and the plaintiff uncovered an obscure scientific paper that documented corrosion of similar materials under similar conditions. The claim was settled in the owner's favor because of that higher standard of care being assumed contractually. Another key exclusion under the policy is the insured versus insured exclusion. So claims from one insured against another insured under the policy are not allowed. There is one exception with one insurance company providing coverage for architects and engineers, but other than that, every other policy contains an insured versus insured exclusion. There's also a related entity exclusion. So if you have a contracting arm and an engineering arm within the same company, if the engineering arm causes a loss to the contracting arm, let's say delays and cost overruns, the contracting arm cannot sue itself, basically, the other subsidiary. Faulty workmanship is excluded unless the loss arises out of professional services. Some policies also have an exclusion for design or manufacture of goods or products. However, typically insurance companies do only exclude mass-produced products. Also be aware of UK forms. They are slightly different than North American forms in terms of the exclusions. So they could exclude consequential losses, which are not normally excluded under North American policies, pollution, asbestos, mold, and there can be limitations also for coverage for cladding and fire safety claims. So know your policy. Every E&O policy also has an other insurance clause. Basically, it states that the policy is primary other than for some other listed insurance, like, other than if the policy would respond to claims covered by some other policies, such as wrap-up or builder's risk. Some policies have slightly broader language, so it is an important clause to negotiate as well. Right now, we will talk about the insurance options for the single project professional liability policies. The policy options are a policy covering architects and engineers, contractors cover, and then a wrap cover covering the contractor plus the architects and engineers under one policy, and then the owner's cover. Multiple policies can be purchased on a single project because each of these policies protects different interests. The most common combinations are the contractor's policy purchased in conjunction with the architects and engineers policy. So the architects and engineers policy, as the name gives away, it covers architects, engineers, and other consultants and sub-consultants under the policy. So the named insured is typically the prime consultant plus its sub-consultants, or the multi-prime plus their subs. Again, it typically requires reporting of any new professionals during the policy term. The coverage is for third-party liability, so it protects the named insureds against losses claimed by clients or third parties and provides defense to the named insureds. Most markets right now do also include mitigation of loss coverage, which is the cost to correct any design errors before they lead to a claim. So it would be possibly rectifying any work done improperly because of these design errors, or taking other preventative measures. The policy trigger is our negligent acts, errors, and omissions in the professional services. And unlike the general liability policy that only covers bodily injury and property damage, the trigger is also financial loss, bodily injury, and property damage. Policy features, as we discussed before, claims made in the reported policy. So the claims must be made and reported within the policy period or the extended reporting period. And defense costs do reduce the policy limits. There is also another endorsement that has been added on, mainly required by US markets. And what it does is the baseline changes endorsement. It outlines conditions that are considered material and that must be reported to the insurer for evaluation. So this would include any large increases in project values, any change in the delivery model, change in project financing or the scope of work, etc. So it is important to read your policy and be aware of what has to be reported. I should also mention that the architects and engineers policy is a basis for all these other policies. So I'm not going to go into an extreme amount of detail. I will only talk about differences between, let's say, the contractors policy and the architects and engineers. So for the contractors policy, the named insured, instead of architects and engineers, this is going to be the contractor entity. And the contractor could also include their subcontractors for coverage, say the mechanical, electrical, all the major subcontractors could be included in this coverage as well. One additional coverage is the protective indemnity. So design claims against design build contractors from third parties do occur, which obviously necessitates the purchase of the professional liability coverage. But professional liability claims are kind of few and far between for this policy type. Rectification is an important coverage. Just keep in mind that it does require insurer pre-approval typically before any amounts are expended. And the third coverage that is optional as well is protective indemnity. But severe design claims on design build projects are usually made by the design build contractor against its design consultants, and this is where this protective indemnity coverage becomes important. It's a first party loss coverage which indemnifies the contractor for the contractor's own loss, like delays and cost overruns caused by the negligence of the subcontractor professionals, so say a geotechnical engineer. The policy provides limits excess over the other professionals' policies, and it does drop down. So if the design professionals, let's say the engineer's policy is eroded because of claims on their annual program, the contractor's policy will drop down and cover the delta between the it will cover the contractor's loss. Also, the contractor's policy might be broader. So to the extent that it's broader, it will cover what the engineer's policy does not cover. Important to note is that the insurance company must be notified at the same time as the claim is made against the subcontracted design professional, and the insurance company has to consent to the settlement. So as a claims example on a design build project, subcontractor surveyor made an error and the contractor put piles in the wrong place on the building project. So first, you could trigger the rectification coverage on the policy in order to correct the position of the piles or to pay for the correction. And then you could trigger the protective indemnity section for delays and cost overruns. So if let's say, the fixed price contract was for $100 million and now it cost the design builder $110 million because of delays and cost overruns, that $10 million could be claimed under the protective indemnity coverage section of the policy. And why is it a good idea for a contractor to purchase this protective indemnity section? Much as we discussed about the need for single project policies, the policies of subcontracted professionals are claims made, and the coverage is not guaranteed for the life of the project. It's the coverage of the subcontracted professionals. It could be subject to annual market availability, changing terms and conditions. Different policies could have different restrictions. It's not uniform coverage. E&O policies typically have defense inside the limits, which can significantly erode limits available for payment of damages. The subcontractors' policies include all historical work under that one aggregate limit of liability, on average 2 to 5 million in Canada. Limitations of liability are often negotiated to fees, and A&Es, as we know, they don't have huge balance sheets to back significant losses. Also, they might cancel or non-renew their policies. Note, the contractor has to sue professionals and obtain settlement and payment under the underlying policy prior to the CPPI responding, and pursuit claims of these costs are not covered. So the use of this policy is really on any project where the contractor is providing professional services, other than on a pure alliance or IPD project, which would require a different structure. Insurers each typically deploy between $5 and $10 million in limits. The retentions really vary by insurer. They can vary significantly from low retentions to millions of dollars. And the duration, some insurers are limited to 10 years, which can be a challenge on larger projects. The next policy type is a wrap that we discussed, which it can cover the contractor plus all the subcontractors, all the architects, engineers, consultants, and subconsultants under one policy. And there is an insured versus insured exclusion, which precludes the contractor from being able to claim against the other insureds. Now, why would a contractor want to do this? Some contractors do have, like we mentioned, engineering arms. They work extremely closely with their design partners and are either willing to forego the suits against the design professionals, or contractually they're still able to sue them, in which case the design professionals might seek coverage under their annual practice policies or obtain a separate A&E single project policy to protect themselves. Much like the contractor's professional policy, there are 3 possible sections. And the protective indemnity is optional. There are policies. We'll talk about the IPDR Alliance shortly, but there may be delivery models requiring only certain professionals to be insured under the policy. So, for example, in the pure IPDR Alliance project policy, only parties to the multi-party agreement, so owner, contractor, architects, engineers, major subs, would be insured under the policy due to the waiver of claims, which precludes the suits amongst these parties to the agreement, as the waiver doesn't apply to professionals outside of the IPDR Alliance agreement. Those parties' policies could be pursued and protective indemnity would apply. So again, the use is any project type where the contractor has responsibility for design. It's particularly relevant for projects where the boundary between design professionals and contractors is blurring. On Alliance IPD projects, it should be noted that the retentions can be really, really significant. Typically, a portion of the risk pool, somewhere between 25 and 35% of the risk pool. The last type of policy that we will discuss is the owner's protective professional indemnity policy, which protects the interest of the owner. And there are 2 policy sections, just the professional liability and protective, which gives the owner the ability to pursue claims against the design professionals, and it will pay excess over the what the owner is able to recoup under the professional's policies or the contractor's policies. 90% of claims paid out under the owner's policies are paid out under this section. The coverage is critical for large, complex projects where owners face long tail risks and potential exposures to high severity claims. The benefits are same as we discussed before in terms of the consultants potentially not carrying significant limits, and their annual policies covering multiple projects. So we only have a few minutes left. The state of the professional liability market, as a lot of you know, insurers' appetite for construction professional is influenced by historical claims, which involve large cost overruns and professional negligence on major infrastructure projects. These claims often stem from fixed price contracts agreed upon with incomplete designs, sometimes under 30%, even as low as 10%, leading to delays and overruns. Complex disputes, multi-year notifications, high defense costs are common, with some insurers facing rectification mitigation claims. rising material costs and legal fees from multi-party litigation add pressure. For straightforward projects in stable regions, rates are stabilizing or slightly declining due to insurer competition. There is increased capacity coming into the marketplace. But on complex projects, if we're talking about tunnels, dams, subways, LRTs, bridges, process plants, energy transition assets, these face firm rates and tighter underwriting. Project-specific professional is perceived as a high severity, long tail risk. We'll just skip this poll in the interest of time.
Yeah, so Elena, I think we have 1 minute left, and I know you have some great content left. Perhaps we could discuss finishing this up at our next session, session 4, but I did want to leave time. We have one question from the audience. So I'll read that out to you. It says, you state that professional liability policies include coverage for defense costs, but who defends the claim? The owner and consultant gets reimbursed for the defense costs, or the contracts require the consultant to actually assume the defense themselves?
So, if the owner sues architects and engineers, let's say we're talking about these two parties, the architects and engineers get defended under their own policy. If contractually the architect assumes the obligation to defend the owner against third-party claims, then the architect has to pay for those defense costs out of their own pocket, unless they're limited to the extent of the architect's negligence, which is what the insurance policy would cover, and that would be paid for by the architect's insurer.
Okay, great. Thank you so much. And with that, it is 10 o'clock. Time flew by. So thanks to both of our presenters today, Ted and Elena. And just a reminder to the audience, we have session 4 of From Bids to Bricks, our last session of the year, happening on December 10th. Hope to see you all there. Thanks so much, everyone. Have a great day. And please do complete our survey. You can see that QR code up on the slide. Thank you.